Roni Reaves open records requests update. Let's get into it. Now I was going to go through all these emails. As you can see right here, 17 back and forth emails. I got the last correspondent from the custodial record, Miss Sarah Humphreys, on January 30th. We talked about it. They said they wasn't giving out legal advice. But I said that was going to be boring. So what I did, I went back to the original email that they sent me. So let's break this down and show you why from the jump, they really had no claim. This story is not they won't release the 911 tapes. This story is they themselves explained the law, admitted releasing 911 tapes in homicide cases, defined pending as immediate court action, and then refused to show any investigator, prosecution, or posture that would legally justify withholding one. Now, this email is from the head 911 office person at the Baldwin County Sheriff's Department. And you guys can screenshot, squeeze in. We're going to go over it in detail, but this is one of the initial emails we got on January 12th when we started this open records request. And in this passage, in the middle, it says, "At this time, I am able to release 2 completely cleared cases from 315 Butler Road and 156 Waller Street. Cab report and 911 calls attached." That matters a lot, right? It confirms 911 audio was released, right? In homicide cases, through the same agencies under the same Open Records Acts. That's not hypothetical. That's precedent created by the county itself. So they understand pending is not forever, right? Still on page 3 right here, the email quotes OCGA subsection 50-18-72A4. And then immediately explains the legal limitations. An investigation or prosecution shall no longer be deemed pending when all direct litigation has become final or otherwise terminated. Then it cites Parker versus Lee and Unified Government of Athens Clarke County versus Athens newspaper, explaining that pending means immediate adjudication. It must be finite. And once no direct litigation is active, the exemption falls away, right? That's the county explaining the law correctly in writing in another case. But here's where they try to play on words. Completely cleared has nothing to do with whether something is pending. They are 2 different legal concepts, and they're mixing them to dodge it, right? What completely cleared actually mean? Cleared in law enforcement terminology is not a legal status. A case can be cleared when someone is arrested, when someone is charged, when someone dies, or they claim they've identified a responsible party. It has 0 automatic relationships to court proceedings, prosecution, appeals, or whether records are public. Cleared does not equal not pending. Uncleared does not equal pending. That's their first trick. What pending actually means in legal terms, pending is not a police concept. Pending is a court concept. Under the statute they themselves quoted and the case they themselves cited, pending equals active, immediate court proceedings of a finite duration, right? That means a prosecutor, a case number, an indictment. Litigation is moving toward adjudication, not we're still looking, not we might prosecute one day, not the statute of limitation has run, right? Not the case isn't cleared, right? This is why they brought up cleared cases at all, because they don't want to say the real thing, right? What they should have said, we are withholding the 911 call because this case is actively pending prosecution. But they can't say that because there is no prosecution. There is no indictment. There is no court order. There is no litigation. There is no timeline. There is no person of interest, right? There is no investigation posture in this case. So instead, they say we only release 911 calls in completely cleared cases. That sentence is policy language, not statutory authority. And policy does not override OCGA subsection 50-18-72A4. That's the quiet contradiction, right? They say we release 911 calls in cleared cases. Then they quote Supreme Court law defending pending as immediate adjudication. Those two things are not linked by law. A case can be uncleared and not pending. A case can be cleared and still pending. A case can be unsolved and not pending. A case can be cold and not pending. They're acting like not cleared equals pending, but Georgia law does not say that anywhere, right? They're substituting cleared, which is a police convenience, right, with pending, a legal requirement. That substitution is not authorized by statute and not supported by case law, right? Georgia law doesn't say records stay secret until a case is cleared. It says they stay secret only while a prosecution is actively pending in court. And those are not the same thing, right? And this is where we got to be careful, people. You look at this document, you look at the last sentence in this document. It say, after that time, a public proceeding has resulted in a decision which has reached a high degree of finality, and there is no basis for an exemption because the prosecution should not be considered to remain undecided. That sentence comes directly from the Georgia Supreme Court's interpretation, not from the sheriff, not from the record custodian, not from policy, right? And this is what it basically says in plain English. After that time, right? The first part, after that time, this refers to after direct litigation is over, meaning no indictment pending, meaning no active prosecution, meaning no appeal moving forward, meaning no immediate court action. A public proceeding has resulted in a decision which has reached a high degree of finality. This does not mean a conviction is required. It means the criminal justice process has stopped moving in court. The case is no longer actively being adjudicated. The system has reached a point of practical finality. Finality does not equal solved. Finality does not equal justice. The finality equals that the courts are no longer engaged. There is no basis for an exemption. That's the kill shot. The court saying once there is no active court process, the open records exemption disappears. Not weakens, not becomes discretionary, disappears. Because the prosecution should not be considered to remain undecided. That directly rejects the idea that we might prosecute someday. Or there's no statute of limitation. We're still looking. The court says that kind of open-ended thinking does not keep a case pending, right? Up until this point, they've been leaning on pending investigation, possible future prosecution, unsolved case. But the Supreme Court is saying if there is no immediate court action, the prosecution is not undecided for the purposes of the exemption. That means pending does not mean unsolved. That means pending does not mean open file. Pending does not mean cold case. Pending does not mean statute of limitations. Right? Quoting case law that limits exemption, then behaving as if the exemption has no end, those two things can't coexist. They can't. Either the case is actively pending or the exemption no longer applies. New media. Stay tuned. Be great today. Peace.